My name is Mike Russo, and I'm the owner of WorkBright. And WorkBright is a consulting company that focuses in on occupational hygiene as well as health and safety consulting. And so I'm glad to be hosting today's webinar with Angela Powell to share some insight on some complex situations involving workers' compensation requirements and also workplace harassment. So welcome, Angela, and thank you for joining me today.
Thank you. Thanks, Mike. And thanks for joining us today. I am a partner at the law firm Sherrard Kuzz here in Toronto, and we represent employers in everything related to employment and labor issues. I'm the lead of the workers' compensation practice here at the firm, and I come from largely a public sector environment. I was at the WSIB for about 12 years there as in the policy area and also as chief legal officer. And thank you so much for joining us today, and happy to chat about some of the topics we're going to get to.
Great. Yeah, thanks. So today's webinar is pretty fast paced. It's 30 minutes. It's designed intentionally to be quick, to give you the information you need so you can get on with your day. And we've done this in the past before, and it's worked out really well. It does move fast. There are questions that you can ask if you can enter those into the Q&A box. We'll get to them at the end of the session if we have time. If not, I will follow up with you to hopefully answer a question you might have. We're going to also follow this up with a survey, if you wouldn't mind taking a few minutes. It's 30 to 40 seconds just to help us improve our services and learn a little bit about what could be improved in today's webinar. So before we get into it and into each of the three lessons, what I thought we could do is, Angela, if you could provide a very brief overview of what those three lessons are. Like I mentioned, today's focus is on workers' compensation and workplace harassment. Much of my time is focused on the prevention side, so I'm interested in learning a lot about what you have to say today and some of the cases that you'll cover.
Yeah, sure. Thanks, Mike. So just a very quick overview of the lessons. Lesson 1 is about how off-duty conduct can still constitute workplace harassment and discrimination in the workplace, and that employers have an obligation to investigate even when a complaint has not been made. Number 2 is going to be about employer responsibility extending beyond the walls of what you think as a traditional workplace when it comes to workers' compensation, and when an employee may have a compensable injury and considered to be at work. And so we'll talk about a couple of workers' comp decisions where employees who were injured while engaged in activity were covered by the workers' comp system. And number 3, the lesson is worker misconduct does not usually impact whether a worker is entitled to receive workers' compensation benefits.
Interesting. So you and I have met before last week, and we went through some of these cases, and they were really eye-opening to me. I think they they're not clear-cut. Every situation, every case had some complexities that I think many employers don't think about when they're handling situations like this. So I'm really interested in learning more about each one of these cases. So just we're going to go into lesson 1 first, and we're going to dive deep into sort of the facts of a case that Angela will share, and then she'll provide a bit of an analysis. And like I said, if you do have any questions, please feel free to enter those into the Q&A, and we'll do our best to get to them. So Angela, maybe let's focus on lesson 1 first, and what the circumstances are, what the lesson is, and sort of the case that you chose to reinforce this lesson.
Yeah, of course. So this case is a bit unusual because it did make its way all the way to the Court of Appeal, but it essentially involves a case where 5 unionized employees were engaged in a chat. So a personal chat using their telephones or personal mobile phones using WhatsApp. And in this chat, they were essentially making derogatory, discriminatory, sexist comments about people in the workplace, but they were making these comments not at work. So on their personal time or through this chat, and no other employees were able to see the chat unless they were part of it. However, one employee who they had been making comments about did become aware of comments that were made about her in the chat, She did mention it to her supervisor. However, she declined to make an official complaint under the employer's workplace harassment and discrimination prevention policy. So no investigation was initially conducted. However, once HR caught wind of this chat among the 5 employees, they decided to conduct an investigation. And ultimately, they found that the 5 employees had breached their workplace policy, and the 5 individuals were terminated with cause from their employment. So the interesting part about it is, of course, the union grieved these terminations, and the arbitrator found that the terminations were too extreme of a action on the part of the employer and reinstated these workers back to the workplace. And the employer appealed that decision, was successful, went to the Court of Appeal, was successful. But the most interesting part about this is that the courts found that regardless of whether that employee who had become aware that this chat was in part about her, it didn't matter that she didn't want to file a complaint. Once the employer became aware that harassment and or discrimination had potentially occurred in breach of their policy, they had an obligation to conduct an investigation. And the Court of Appeal specifically spoke to the employer's obligation under the Occupational Health and Safety Act and indicated that, regardless of what the policy said, that in order to maintain a safe workplace, that the employer's obligation in OSHA sort of overrode everything else, and that they did have to conduct an investigation. The court also found that just because the chat was, among these employees outside of the workplace using their personal phones, that it was still deemed to be work-related because it did have an impact on individuals in the workplace, specifically this one woman who had discovered that the chat existed and that they had made comments about her. And so I think that, before I turn it back to you, and I'd be interested in hearing your thoughts, Mike, I think a couple of the critical points, coming out of this decision is that, off-duty conduct of the employees that does impact the workplace, can impact their employment, can lead to discipline or even termination, depending on if an investigation occurs. So make sure you look at your workplace policies to see if they speak to off-duty conduct. This employer's policy did speak to off-duty conduct and also spoke to the use of social media and it impacting the workplace. And also be sure to understand that as an employer, if you become aware of something that looks like discrimination or harassment, you actually do have an obligation to investigate, even if the so-called victim or individual employee who's being targeted chooses not to file a formal complaint.
Interesting. So this is a whole new world we live in today compared to 10, 15 years ago. I mean, social media, email, text message groups, these are all things that play out on a daily basis in many workplaces, if not all workplaces. So this is a real big issue. But I think the point that you mentioned, the fact that, there was a duty to investigate regardless of, the individual's desire to proceed with an investigation. Is that something that you commonly see? And does that typically trip up employers?
I think employers are becoming more aware of their obligations in this space because of decisions like this and because of education around obligations under the Occupational Health and Safety Act. But certainly I do think that the human inclination is if someone doesn't want to file a complaint, that there's nothing to investigate, right? But that's not the way that decision makers actually look at this type of situation. They look at the victim as the workplace as a whole and the type of perhaps toxic environment it's creating, not necessarily focusing only on the specific person who has been wronged or the target of discriminatory or harassing conduct. So important to keep in mind that courts really look at the employer's duty as being to the workplace as a whole and not only to specific individuals.
Interesting. Yeah, that's a situation I've seen many times play out, just dealing with the organization, myself included as a manager in the past, where you have individuals bring forward some, concern that doesn't seem like much, but I think that's important to your point, where, once that is made aware that there's a duty to investigate. So in this case, I guess the outcome, the repercussion was too severe in the eyes of the court?
It was too severe in the eyes of the arbitrator. The court didn't really speak to the repercussion. They were looking at whether the arbitrator's decision was reasonable. They found that it was not reasonable. And so the remedy in this situation is they referred it back and asked that a new arbitrator be appointed and that the issue be heard and decided again. This decision was in 2025 from the court, so not sure if it's actually proceeded through arbitration again, it only being 2026, and these things don't tend to move that quickly. But yeah, so the remedy in this case was basically a new decision.
Okay, so that's good to know. And I guess, from an employer's perspective, is it wise to inform someone who brings forward a concern that the company has an obligation to investigate? Is that something that you see often play out?
Yes, I would say so. And so, once, so the employer in this case, I believe, became aware of the situation from another source when HR actually decided to conduct the investigation. But I think individuals need to know that once they come forward with a complaint, it's not really their decision with regard to whether the employer investigates. It triggers an obligation on the part of the employer. And, I think education for individuals in the workplace is always helpful, and having really clear policies as well, which speak to the fact that, the employer does have certain obligations under the law. And, once aware that a problem may exist, they need to look into it further.
Great. Yeah, thanks. That's lesson one. So we're about 12 minutes into this webinar, not much time left. We're going to move on. Like I said, if you do have any questions, feel free to enter those into the chat, and we'll do our best to get to them at the very end. Let's move on to lesson two. I think this one for me hits home because previous to health and safety in my very early career, before I started, I worked at many different corporate functions, and probably over 1,000 in my lifetime when I was younger. And I saw many questionable behaviors and activities play out at some of these company functions. And I think in lesson two, there's a couple of cases that reinforce, this complex situation. So maybe you can share a little bit about what lesson two is and what happened in the cases that you chose.
Yeah, sure. So for lesson two, we chose a couple of cases. One is a very recent case that generated quite a few calls from employers to me when the case came out. And so that's one reason why I think it's of interest. So the first case is essentially an employee of a university left the building that they work in and went to another building on the university campus during a scheduled break to briefly attend a Weight Watchers weigh-in. So this wasn't part of her job, obviously, and she was attending the meeting on a break. The university wasn't responsible for the meeting, but they allowed their space to be used by Weight Watchers for this meeting. And while in attendance at the meeting, she tripped and fell and ended up getting a concussion. And so the tribunal in this case allowed the claim as work-related. Obviously, the employer, the university, argued that it wasn't work-related because this employee was not in the course of her work-related duties, while her injury occurred. She was on a scheduled break. But it's an example of where both the WSIB and the tribunal look at time, place, and activity. Those are the key factors that they look at to determine whether someone was in the course of their employment when they get injured. And they really noted that if the employer condones the activity, so the employer, the university more broadly, knew that Weight Watchers was having these meetings on campus, it was a personal activity, but the location of the activity didn't really take this employee outside of the course of her employment. It was still on the campus, even though it wasn't in the building that she worked in. But it's important to note too, I'll use a second example to talk a little bit more before I talk about the implications, that it doesn't even just have to be a personal activity that occurs on or near the worker's premises. So the second example is about an activity that was organized by an employer that wasn't in the workplace at all. It was in a separate location after work. Sorry, I'm turning my motion lights on. The second activity was organized by the social committee of an employer. There was some sort of like balloon stomping, event that was occurring at this activity, and an individual was injured while in the course of doing that as well. Again, the tribunal found that the individual was in the course of her employment because of place, time, and activity. And I would say the general lesson to take away from both of these cases is that the board and the tribunal really look broadly at time, place, and activity when looking at whether a worker was in the course of their employment. When it comes to an activity that was planned by an employer, they often look at, whether the employer sponsored the activity, whether the workers were provided with time off to engage in the activity. So I'm thinking of like an employer-sponsored softball match or, some sort of team building activity that perhaps the employer has planned off-site. Is attendance mandatory or encouraged? Is the employer getting a benefit from the activity in that it's meant to improve, the culture, at the company? Did the employer pay for the activity? So all of these types of indications will generally lead to the board and tribunal finding that an injury that occurs in that situation is compensable, and which ultimately results in costs to an employer, whether that be through premiums or direct costs. So I would say the critical points for both of these decisions is, when planning a workplace social event, consider low risk options if possible. I know that people really like sporting events. I've seen volleyball, dodgeball, softball, you name it. Just be aware that if an injury does occur, then if you do have workers' compensation coverage, you're likely going to end up with an allowed claim. And consider whether the event has a significant employment relationship and connection with the employer. Like, are you allowing people to bring their friends, their spouses? In that case, it may bring it outside of the course of employment. But as Mike alluded to at the beginning of this conversation, these are also fact specific that, you really do need to carefully consider what you're planning, and just be aware that if someone is injured, you may end up with an allowed claim.
Yeah, and it's a really good point, because I've seen many team building events where I would say, they're participating in higher risk activities, rock climbing, volleyball. I've been at an event where a worker broke their leg while it was a company sponsored volleyball event after hours, a boat party. So many different company functions that I think employers need to really think about what you just said, and consider lower risk options perhaps to minimize the risk. I think there's going to be some assumed risk involved at some point, but lowering the risk, I think, can go a long way. Great. So we're moving along. We've got about 12 minutes left, and I want to move on to the third lesson. This one was an interesting one, because I think most people, when they hear the facts, are going to think there's no chance that this claim would be allowed. But maybe you can shed a little light on what happened and the lesson to be learned.
Sure. So this is a 2019 case, and in this case, there was a road crew foreman, and he was required each day driving the company vehicle to pick up coworkers, drive them to the site, and then at the end of the day, drop them off at their home on his way home from work. And so in this particular instance, after work, there was a motor vehicle accident. It was discovered at the time of the accident that the road crew foreman who was driving was under the influence. He was actually over the legal limit. He and the other coworkers had been drinking after work before driving home. And the driver actually ended up with a very serious spinal cord injury. So, the employer did not want this to be allowed as a compensable claim, and argued that, obviously this employee was engaged in serious misconduct, drinking at the end of the workday, and then driving his coworkers while intoxicated. And, it was the employer's position that this should not be a compensable accident. I think that it's really important to remember that workers' comp is a no-fault system. And so I hear this a lot, where, maybe in an industrial setting, you'll have an employer say, well, this person was trained, they received training, and they were engaged in unsafe practices, or they weren't using a piece of machinery properly as they were trained. Perhaps they removed a guard, something like that without authorization. And a lot of employers are surprised to learn that the WSIB doesn't care about any of that. It doesn't really matter what caused the accident, and even if the worker themselves was negligent, or in this case engaged in arguably intentional misconduct, it doesn't take them outside of the workers' compensation system. They're simply interested in whether the accident occurred in the course of employment. And so in this case, the WSIB did pay the worker benefits, and obviously it would end up being very costly claim as this individual had a catastrophic injury coming out of the motor vehicle accident. I think critical points to take away in this is ensure that there are very clear health and safety protocols related to the activity that this worker was engaged in. So when you're responsible for driving others, but also in some of the other circumstances I talked about in a more industrial setting, that not only do you provide the training to workers, but that you regularly monitor and audit that they're actually complying with the training and the proper operating of machinery and so on. Because if they do end up getting injured, they're likely going to have a compensable claim again, which is potentially going to be quite costly for the employer.
Yeah, that's a great point. And I think I see this a lot, especially when it comes to health and safety training, that, oftentimes want to provide training thinking that it's, simply a way to demonstrate due diligence. But if what is being trained is not practiced in the workplace, really doesn't matter. And I think the other thing I often see, you mentioned, WSI or workers' compensation being no fault system, is that I've encountered situations sometimes where employers want to have an employee sign off or waive a certain right, but I think that counters to what you said, and that's not necessarily a possibility. Is that something that you've seen in the past or have encountered?
I've encountered it there, but also it's helpful for employers to know that, even if you have other issues going on, so it's not uncommon for an employer to have a grievance and, a human rights complaint, maybe a health and safety issue. And sometimes the parties will agree to enter into a settlement to settle all of those issues. You cannot enter into a settlement to settle workers' compensation matters. And so if you also have a workers' comp claim associated with those matters and you include it in a settlement, it's void as far as the WSIB is concerned. There's actually a provision in the legislation saying that you cannot contract out of the workers' compensation system. And so that can be really frustrating for employers who oftentimes are just looking to, enter into some sort of universal settlement to just settle, all related issues. And it's helpful to remember that that's not possible from a workers' comp perspective for the most part.
Interesting. So at the end of the day, regardless of an employee's misconduct, if it results in an injury and a compensation claim, it will likely be allowed in some cases, in most
It
cases.
will likely, yeah, it will likely be allowed. The WSIB has a bizarre policy called horseplay and larking. You can all look up larking because
everybody's Googling right now.
Yeah, but essentially they do have a policy where in some instances a worker's conduct can take them outside of the workers' compensation system. It's very limited, but it will be, for example, getting into a fist fight with someone at work, or being overtly negligent and engaging in horseplay and fooling around in a setting where there's a risk to themselves and others. There are some limited circumstances where the board will refuse to compensate that.
Interesting. Excellent. So that brings us to the end of 3 lessons. And what I'd like to do now is open up the Q&A. We do have a few questions, and I'm going to go through them one by one. Like I mentioned, just a reminder that there will be a survey that's put into the chat near the end or soon. But also a follow-up email with that same survey. If you wouldn't mind, it'd be very helpful to me just to share a little bit about your thoughts on today's webinar, and we'll look to potentially carry out more of these in the future. I want to go back to I think our first case here is a question that came in. So this is in regards to the 5 employees, the case involving the 5 employees, and the situation involving workplace harassment. So one attendee's question is, couldn't this lead to more fallout for the employee that was being harassed, specifically if they wish to not have this investigated? So I think we touched on this very briefly. If the person who brings forward a complaint chooses not to investigate, does that not result in more fallout? I think you partially answered that, but maybe we could spend a little more time, because I think this is a big issue. I think this happens very often in many workplaces.
Yeah, I mean, I think part of it is a workplace culture issue, I think, and that there have to be, or there should be really explicit conversations about what's acceptable, what isn't acceptable, conduct. And also everyone needs to understand that if the employer becomes aware that something is going on that may fall within, discrimination or harassment, that they have to investigate. So no potential complainant or individual employee should be surprised to learn that the employer, once informed or once aware, that they have their own obligations to proceed with an investigation. So that shouldn't be something that employees are hearing for the first time when they go to HR or their supervisor with a complaint. That should be well known. And of course, there are rules against reprisal, right?
Mhm.
For, making complaints or, certainly a new complaint can come out of fellow employees, like such as in this case, if any of these 5 employees started harassing the individual for making the complaint or
Yeah.
making the employer aware of it, there are implications, for those employees related to that too. So I think a lot of it is just making sure that everyone understands what's in your policy so that individuals won't be surprised if they do bring something forward to learn that it's actually not their choice, whether it's ultimately investigated or not.
Yeah, and it makes you wonder if, if you follow that policy, whether it potentially suppresses complaints or reports, potentially. I've heard of that in some situations where, if we have this policy that we have to investigate, does that suppress concerns being brought forward? And, there's a lot to think about and unpack there. So I do want to move on to a next question. This is still involving scenario one. I think scenario one is a very common concern in many workplaces. So this question is, can the off-duty situation apply in a scenario where coworkers go and grab a few beers after work, which is completely voluntary, and there's a situation of violence and harassment? So I think this is, more after hours, similar to the situation involving the chat, but maybe leading to violence. There is an altercation, a fight, physical violence that transpires. Is there any situation that you've encountered or any potential recommendation on sort of managing those types of situations that are somewhat connected to the workplace, or perhaps they are considered connected to the workplace? But how would an employer best manage situations like that?
Yeah, I think, the key that the court talked about in this decision is whether it will impact the workplace, whether it ties back to the workplace. And there was a recent case, I can't recall the name of it, but I believe there have been a few recent cases where there has been a fight, offsite, and it was considered work related, particularly when it was sort of perhaps a disagreement arose in the workplace and then it transitioned into a fight offsite after hours, right? So the disagreement or the interpersonal conflict really started in the workplace, but then resulted in a fight perhaps somewhere else. And so that would definitely be tied to the workplace. And so all of these are so fact specific that I know it is tricky for employers to manage, but certainly if whatever happens outside of the workplace would be expected to impact what's happening inside the workplace, it's incumbent upon the employer to investigate. Interestingly, though, the judge in this case indicated, if these 5 employees were just at one of their homes, sitting around a barbecue, trash talking their coworkers, and the coworkers had never heard of it, no one heard about it, would it be discrimination and harassment? And they said probably not. Right. And so that really seems to be splitting hairs, I'm sure. But a lot of it is related to whether it can be tied back to the workplace or whether it's impacting the workplace.
Interesting. Yeah, it is very case specific, but I think the scenario itself plays out in many workplaces, like I said. So let's move on to the next question. As the final question, I think we'll be at the end of our webinar. So this is in regards to case number 3. Was the claim found allowable specifically because the worker was driving other workers, for example, carpooling other employees? In a situation where where this might become a work-related activity compared to regular commuting between place of residence and the workplace. So I think what the individual's asking here is if there are different scenarios where someone may be commuting to and from work from their home versus carpooling. Maybe they're, a group of workers have agreed to a carpool agreement, and how does that play out in regards to the situation in case 3?
I think in this case, it certainly was a factor that the individual was driving a vehicle owned by the employer. And that it was seemed to be part of their regular workday every day to drive coworkers to and from the workplace. I will say that the WSIB does have a travel policy. And, there are also instances, particularly for employees who are on the road as part of their job. So for some people, they go to multiple locations during the day, and their day really starts as soon as they leave their home. Certainly, even in cases, there have been cases where workers' comp claims have been allowed, where an individual is driving from their home to their first location of the day, or conversely from the last location to their home, because they're considered to be in the course of employment, even when they're driving their personal vehicle. And they do not have any coworkers with them.
Interesting. A lot to think about. So just like that, 30 minutes is up and done. Angela, thank you so much for joining me. I think this has been a great conversation. I know that there's a lot more we can talk about in regards to each of the cases you covered, but I think this gives a lot of people who attended some food for thought and how these are potentially implications for their own workplace and how to manage these situations a little bit better. Just a reminder, I will be emailing out a survey, as well as this session will be recorded, so you can refer back to it in the future. Angela, thank you again, and I want to thank everybody for joining me today. And if you do have any questions, feel free to reach out. Take care.
Thanks, everyone.